Hello, everybody. Welcome to tonight's episode of the Debt Hotline. Thank you all for joining. Thank you all for listening. We're excited to talk about a really common question that we get at Solo tonight. That question is, what do debt collectors actually have to provide as far as documentation goes to prove that they have the right to collect a debt? And we have a very special guest tonight. I'm going to go ahead and give a quick intro for our guest, and then we'll jump right into some questions. So, tonight we are joined by Greg Anjewierden of Debtbrief. Greg is a licensed and practicing attorney. He used to work as a debt collection lawyer and collected unpaid medical debt. So, he knows a lot about the debt collection litigation process and debt lawsuits in general. And because of his experience, he knows all the inner workings of how this system works. And, related to our topic tonight of what collectors must prove to win a debt lawsuit, he knows exactly the type of documentation that is needed in order to win a case. So he is also the founder and CEO of Debtbrief, which is a company that helps people who are sued for debt with consulting, legal representation, forms, courses, and other resources. Again, that's Debtbrief. We're really excited to have Greg on tonight. Greg, did I miss anything? Is there anything you'd like to add to that intro?
Nope, that sounds great. I'm just happy to be here.
Yeah, thank you so much for taking the time, Greg, to join. And for anyone who is watching live tonight, you can drop your questions in the chat. We received a lot of questions on the debt hotline before we went live tonight. And so we'll be addressing a lot of those questions, and we'll be getting to a few in the chat as well. But for, hopefully if we don't get to your particular question tonight, hopefully some of the other questions that we answer will answer it as well. So that being said, wanted to dive right into this topic. So tonight's topic again is Debt Lawsuits 101, what collectors must prove to win. This is a very common question we get at Solo, like I said before. People are always wondering if they've been sued by a debt collector, what does the debt collector have to prove and file with the court to show that they actually have the right to sue or collect a debt. So with that in mind, Greg, I wanted to jump right into my first question, which is, when a debt collector files a lawsuit, what are the bare minimum things that they must prove in order to win the case?
Okay, so typically they've got to prove one or two things depending on what type of plaintiff they are. So we'll start off if for example, you had an American Express card and it's American Express suing you, so the original creditor. They need to prove that you had a contract with them and you breached that contract. In other words, they've got to prove you owe the money. If it's like a third-party debt collector, like a junk debt buyer, someone like Midland Funding or LVNV Funding, something like that, then they've got an additional thing they need to prove, and that is that they own the right to collect on the debt. So there's got to be some kind of contract between the original creditor and the debt collector that's suing. So I like to think of it as, two things. Do you owe the debt? And the second thing is, do they own the right to collect the debt?
So for those who might not be as familiar with this debt collection process, how does it typically work, Greg? Like if, let's say, I know you collected unpaid medical debt, right, back in the day. So if a hospital hires like a third-party debt collector to collect debts for them, how does that transfer work usually? Greg, are you with me still?
I'm here. Okay, am I back?
Yep, we're back.
Internet for a minute.
Okay, perfect. Glad you're back. I'll just ask my question again. So I was wondering, for those who aren't familiar with the debt collection process, I know that you particularly used to help collect unpaid medical debts. So can you explain how that process typically works? Maybe if a hospital, is trying to collect unpaid bills, they will maybe hire a third-party debt collection agency, or if they've gotten to the point where they want to sue for it, maybe they'll hire a law firm. Can you tell us a little bit about how that transfer of ownership and debt works?
Yeah, it can happen in a couple of ways. The first being that, a lot of times they'll just hire a debt collection company to come after you. So they'll just say, hey, here's these accounts, and maybe they say you can have a percentage of whatever you collect or whatever. They don't actually transfer ownership of the account. And so you might get a debt collector that's always calling you or hounding you, right? and so it could be some debt collector that actually doesn't own the debt, but they're just doing this work on behalf of the original creditor, the hospital or the doctor or whoever, right? Now, where this really comes into play is when it comes time to file a lawsuit, because the person who files the lawsuit, in other words, the plaintiff, has to be, the name of the plaintiff has to be the party who has the right to collect on the debt. So let's say that the debt is a hospital debt. We'll call it ABC Hospital. And they hire, debt collector to collect on this account. Debt collector cannot file the lawsuit with debt collector as the plaintiff. The plaintiff has to be ABC Hospital. Now, the other way they can do this is they can actually sell the debt to a debt buyer. So they might say, instead of hiring the debt collector and saying, hey, will you collect this for us? You get a percentage of whatever you can get. They'll actually sell the debt. So if it's a $10,000 debt, they might sell it to the debt collector for $500. The hospital walks away and says, well, at least we got $500 and we don't ever have to worry about this anymore. So then the debt collector, they have to have a contract between the two of them where the debt collector purchases the rights under the contract. Then when they file the lawsuit, the plaintiff would read debt collector. But if the plaintiff is listed as debt collector, they've got that extra step to prove, which is they have to prove that they have contracted with the original creditor and now have the right to collect. And I have seen it where they didn't contract, they just hired him to do it, and they've made a mistake and filed the lawsuit on behalf of the debt collector. If that happens to you and they can't produce the contract showing the purchase, you're going to win that case. So hopefully it's kind of complicated, but I hope that makes sense the way I've described it.
No, I think it's making a lot of sense. So just to kind of summarize, a creditor, whether it's a hospital or like a bank, maybe a credit card issuer, whatever it is, the creditor can hire a debt collector to collect on their behalf. If they want to sue and they haven't sold the debt to someone, to like a third party, then they would hire a law firm, but it would still be the creditor that is suing. It's not
what
the
you're
law
looking at. Yeah. And what you're looking at when you get that lawsuit on the summons and the complaint, you're looking at who's the plaintiff.
Yes.
Right. Like that's the thing you're looking at. And where people get confused too is because you throw a law firm into there, the law firm is also going to be listed and they're going to be like, well, this law firm is suing you. Well, the law firm is suing you on behalf of the plaintiff.
Yes. So the law firm represents the plaintiff.
Yes.
Now, if the creditor has sold your debt, maybe to a third party debt buyer, so very common ones that we hear: LV&B Funding, Velocity Investments, Midland Funding. If they sell it to a third party, or if they sell it to a debt buyer, then the debt buyer can then sue as well.
Yes, and they would be listed as the plaintiff, but then during the course of the lawsuit, they're going to have to produce the contract that shows that they have purchased the debt.
Okay, and that's really the core of tonight's topic, right? Like what kind of documents exactly do these debt buyers or debt collectors have to produce if they have sued you, and what kind of documents do they need to win their case, basically?
Yeah.
So I guess that leads to my next question. What role does the original contract or agreement play in these types of cases? So you kind of went into it a little bit, but again, like if a creditor has an original credit card agreement with you, and then they sell your debt to a debt buyer, what does the original contract or agreement? What role does that original agreement play once that debt has been transferred or sold to a debt buyer?
Yeah. So if a debt buyer has purchased the debt, they still have to prove all the things that the original creditor would have had to prove. So if it's a credit card, they're still going to have to prove that you entered into an agreement with the credit card company, right? So it doesn't, get rid of the other things that the credit card company would have had to prove. They still have to prove that. Now that's usually done with a credit card agreement, but it doesn't have to be. So the way I like to think about this is, and I think there's a common misconception that people are like, well, if they don't have the credit card agreement, they can't win this case, which isn't entirely true. You have to think about it like, everybody knows the scales of justice, right? And you got the scales here, and they're going to put all their proof onto their scale, and it's going to tip, and you're going to make your arguments, put your proof, and it's like, which way does the judge think it's leaning? So what are the kinds of things that they need to prove that there was a contract? Well, the original credit card agreement. right? Now, most times these days, when you get a credit card, you're probably filling out a form online. So do they have the, form input that you put into their website to get the credit card? Do they have that information? Do they have the credit card statements that show the individual purchases? These are the kinds of documents that you're looking for to determine, can they prove that I owe? Now, if they don't have all of them, or they have some of them but not all, that doesn't mean that they don't win. It just makes their scales tip a little bit more in your favor, right? So you never want to get caught up and say, oh, well, they don't have that, credit card form input from me, so they're not going to beat me. Well, the judge still could look at it and be convincing. I've seen credit card companies win cases where all they have is a single statement that says past due balance and a number. And a credit card company can still beat you with just that document. So, but those are really the kinds of things you're looking for. Is there an original? And if it's not a credit card, if it's like a loan, there's going to be some contract you signed. Like, do they have that contract? And the more of that stuff they have, the more likely the scales are going to tip in their favor.
Perfect. So that sounds like it's more in the case of being sued by an original creditor.
Well, it's going to be the same either way, right? Because whether it's the original creditor or a debt buyer, they always have to prove that first step.
Okay.
Do you owe the debt? Did you have a contract and did you breach it? Every plaintiff that sues you for a debt is going to have to prove that part of it.
Got it. And once the debt gets transferred, are there certain names for the documentation that they need to provide, that a debt buyer would need to provide for that transfership of ownership?
Yeah, so there's not a specific name that they have to use. It's not like, oh, they've used the name and they've checked their box. It could be named almost anything. I think what I see most often is like purchase agreement or purchasing contract, sales agreement, debt buying agreement. I mean, something along those lines. It doesn't have to even have a name, though. I think the important part of what you're looking at is the substance of that document, which is, does it say that you had a contract with the original creditor and that the debt buyer is buying that contract or the rights under that contract? So really the language of the agreement is more what you're concerned with than the name. But typically if you're asking for it, it's going to be purchase agreement or something like that.
Okay, so purchase agreement could kind of be the shorthand for the documentation that debt buyers need when they are buying a debt from an original creditor and then pursuing you and taking legal action to collect that debt from you.
Yes.
So we also, a very common, I guess, phrase that we hear in this space is chain of assignment. Can you explain, Greg, what a chain of assignment means, what that might look like in action in this whole debt litigation process?
Yeah. So when you're talking about chain of assignment, it's, can they trace the debt ownership from the plaintiff that is suing you all the way back to the original creditor? So what we've been talking about today is like, okay, you've got a contract with the original creditor, and then you've got a debt buyer that purchases it. That purchase agreement, what we're calling it today, shows the chain of assignment from the original creditor to the first debt buyer. But this debt buyer can then sell it to debt buyer 2 and debt buyer 3 and debt buyer 4. There's got to be a purchase agreement in between every one of those links. So a chain of assignment is going to be, can they go from the plaintiff all the way back to the original contract? And they've got to have contracts for every one of those steps.
Okay, so that actually leads really nicely into my next question. What kind of documentation issues have you seen in your experience, Greg, that most often lead to debt collectors maybe not being able to prove their case?
Okay, so the first one, when we're talking about this chain of assignment, usually they've got some, I think it's very rare where they don't have anything. I mean, it happens. And if they don't have anything, now theoretically, they could still win that case if they have a witness come and say, but that's, I think, an unlikely scenario, right? So usually they've got some kind of documentation. But what I see a lot in cases that you can really latch onto and make a good argument to win the case is that purchase agreement or assignment agreement, whatever, it does not specifically mention your debt. So what's really common in these situations, they don't buy like single debts at a time usually. It's usually like a big batch. and they'll have like one page that's like Midland Funding is purchasing from Discover Card, a big batch of bad debts. And if you're looking for like, well, how can I make this argument? Does it have your name in that agreement somewhere? Does it have your account number? Does it mention you in any way? And where you can really make a lot of headway is say, that agreement doesn't mention anything about me.
Mhm.
So you can say, we don't know if it covers my debt or not. And since they have the burden of proof, that's your argument to win the case. That's probably the most common argument I can see that will help you with this kind of thing.
So one thing that we see a lot at Solo that debt buyers will do is when people ask for debt validation, instead of, oftentimes, not all debt buyers, but instead of potentially submitting the chain of assignment or the purchase agreement, like we talked about, they'll just send a copy of the original, like, credit card agreement, for example. So I guess my question there is, is that enough documentation if they just have the original agreement? They don't have necessarily the purchase of the debt that occurred when they took ownership of the debt?
So if they've got a credit card agreement but not a purchase agreement and the plaintiff is a debt buyer,
Mhm.
then your argument is no, they don't have enough.
Mhm.
Because they've proven step one, which is that you owe the debt under the contract, but they haven't proven step two, which is they own the right to collect on that debt.
Got
Right?
it.
I mean, certainly that's going to be my argument. Now, like I said, it's not a black and white, cut and dry line like that, though. They don't have it, they lose. Now, how could they still win, though? You think like, well, they could walk into trial with a witness that works for the debt buyer. And sometimes you'll see this in the form of an affidavit, right? They'll send you an affidavit and they'll say, oh, yeah, LVNV Funding has bought this debt from the payday loan company. Now, that's not a great case for them because now the judge has to say, well, do I really believe this person if they don't have any documentation? So I think it's a weak case for a plaintiff, but it is technically possible for them to still win even without that documentation. I just think it's unlikely. It puts you in a really good position, at least.
Awesome. Well, Greg, I think that's a good starter for tonight's topic, and we have several questions specific questions for real people who are dealing with debt situations that have been submitted to the debt hotline. We also have people watching live, submitting questions to the live chat. So we're going to go ahead and jump into some of these real questions now. Let's start off with Ken in Illinois. So Ken says, what documents must the plaintiff show that unequivocally shows that I am responsible for the debt amount that is being sought? Kind of touched on this already, but again, it's related to the topic.
Yeah, I think you got to be careful with the word unequivocally, right? Because like I'm saying, it's never going to be cut and dried, right? Even if they've got the documents, can you say, well, can they verify that those are real documents, that they haven't just made them? I mean, there's always arguments to be made, right? But when I meet with people, I'm going to tell them, if they've got these things, they're probably going to beat you. And that is, do they have the original contract that you entered into? Do they have, if it's like a loan or a credit card, something like that, do they have the statement showing how much and how they got to that number? And then if there's a debt buyer, do they have that purchase agreement? And if they've got those three things, they are most likely going to beat you.
Okay, awesome. So let's see. We got another question from Gail in Florida. Gail says, should I reach out to settle out of court or should I wait until my trial date?
I mean, both, I guess, is what I would say to that. I certainly think that you should always be thinking about settlement. Whether you reach out to settle or not, it should always be a consideration. And what I do when I get a case is I'm looking at, okay, do they have these documents that we're talking about, right? And if they've got them, that makes it more likely that I'm going to try and reach out and settle because I'm not feeling comfortable with my position taking this case to trial because I know they've got a lot of, documentary evidence. Now, what I am thinking is, do I have the leverage that I want, or at least have I given myself as much leverage as I can in a settlement negotiation? For example, if they have served me with a summons and I haven't yet filed an answer, I'm probably using solo suit to file an answer before I try and settle, because then I'm giving myself a little bit of leverage by showing them that I'm willing to defend the case. They're not going to get a default judgment against me, and they've got some work to do. And after I file the answer, then I'm probably using solo settle or going on my own and trying to settle the case at that point. Now, maybe a settlement doesn't get done at that stage. At that point, you can always settle a case at any point. So it's very common for cases to settle at maybe a later hearing when you and the attorney are in the same room, or you get to trial. It's extremely common for cases to settle right before trial. And actually, I don't think most people understand this, but if you go to trial and lose and they get a judgment and they've started to garnish your wages, you actually can still settle at that point. Now, it's harder to do and it's going to be difficult to get a good deal, but there's nothing that says that you can't settle at any point.
Yeah, I think that's really helpful to know that, some people think once they get sued, like everything is over, there's no way to resolve this. Actually, in many cases, if you've been sued and you file an answer, so you block that default judgment, you're in a very good position to potentially negotiate and settle your debt for less.
And look, the attorneys, they know the game. Like, they know how they're expect. Now, maybe you don't like the settlement that they offer you, right? But like, I don't think I've ever had a debt collection case where the attorney wasn't willing to discuss settlement on the other side. Maybe we didn't get a deal done, or I didn't like their offer or whatever, but I think in every case I've ever had, they've at least been willing to discuss it.
Yeah, so I think that's something that's important to realize. If you are being sued, don't hide from the collector. Your chances of resolving the matter and also saving money in the long run are much better if you are open with your communication. If you take initiative, you don't ignore it or try to avoid the situation, but be proactive, reach out, and see what your options are. Most collectors will work with you. And I can say that speaking from personal experience. I was negotiating with a debt collector this week about a medical debt. So that was fun times. But yeah, I went ahead and dropped a link in the live chat for anyone watching. If you've been sued for a debt, and you want to respond, you can use our debt answer at solosuit.com. And you can also use our solo settle tool to negotiate and settle the debt before your court date. I agree with Greg. I think that in many cases, it's going to be easier to try to settle before the court date as opposed to after a judgment has been entered in the case. So great. Let's see. Our next question comes from Sandy in Texas. Sandy says, if there were fraud charges on a PayPal account and I reported them to PayPal and Synchrony, 2 to 3 years later, they are on my credit report and even bigger. I have filed an identity report with the FBI and sent the report to Synchrony and Experian. My PayPal is not accessible and I have not signed it in 2 years. I thought these were cleared and they are in collections. What can I do? Will Synchrony clear the fraud charges? So sadly, this is something that happens often. People get sued or there's a major hit to their credit because of a fraudulent charge. Greg, do you have any thoughts on this?
Yeah, the first thought is I think people kind of loop or link together their credit report and getting sued. There are two different things with two different processes, right? So if you're talking about like, oh, this is showing up on my credit report and I don't want it on there, then that's something that you need to go through the dispute process with the credit bureaus, right? You've got your report to the FBI, which is exactly what you should do. You've got your fraud report to PayPal, which is exactly what you should have done. And you submit that documentation to the credit bureaus through their dispute process and try and get rid of it that way. Now, if Synchrony is now suing you or threatening to sue you, that's a different process, right? So now you're going to court and they've got to prove that you owe this, and they'll say, well, look, she had a PayPal account. The charges are obviously there, right? So in some ways it's looking like, well, this is an easy open and shut case for them. Well, now you've got to come up with your affirmative defense, which is identity theft and fraud. And you're going to the court and saying, this wasn't me. Your testimony is going to be sufficient for that. But the fact that you've made an FBI report and reported it as fraud to PayPal is going to be helpful evidence to you. And I think that's the key when we're talking about identity theft and fraud, is making a police report or FBI report, whatever it is. And if you show up to a judge and say, look, I reported this to the police, the judge is going to be much more likely to believe you, because making a false report is a crime. So, the fact that you're putting your integrity, your criminal history on the line to say this is going to mean something to a judge. So if you're going to court over this, that's exactly what I'd do. Is I'd show up in court and I would present the evidence of the reports that I've made and tell the judge, this wasn't me. I didn't do this. This is fraud. I've reported it, and beat the case that way, which is, again, you've got to treat the lawsuit and the credit report dispute as two separate processes.
Yeah, I think the most important thing, if your identity has been stolen, is that you do need to file a police report.
Mm-hmm.
That police report, the court's going to ask for it. The credit bureaus are going to ask for it. So it's definitely going to be an important piece of documentation.
I'll tell you, I have seen a case where someone showed up in court and said this was identity theft, and the judge asked point blank, did you file a police report? And the person said, no, I didn't know I needed to do that. And the judge said, then I don't believe you, and ruled against them, which is why I always tell people, make that police report. Now, that doesn't sound fair, and quite frankly, probably wasn't, but it was the reality of that case.
Yeah, that's crazy. Yeah, so I guess moral of the story is, if your identity is stolen, file a police report before you do anything else, and then you'll have that proof that your identity was stolen.
And the fact of the matter is, the police probably aren't going to be able to do anything, right? Like, the police aren't going to find this person that has stolen your identity, most likely. It's the fact that you've made the report that is going to be the helpful proof for you. Because again, making a false report is a crime. So you have made yourself more credible by making a police report.
Love it. Okay, let's see. We have an audio question. I'm going to go ahead and play it. Somebody called in to the debt hotline. Let's see. All right, Greg, let me know if there are any issues with the audio, but here is a question that was submitted to the debt hotline.
My question is if it's proper or allowed to contact the complainant's or the plaintiff's attorney or even the plaintiff directly to try to resolve the matter before it goes to court, if it's acceptable to do that. Thank you.
Okay, so if they have an attorney, not only is it appropriate, I think it's recommended that you reach out, or use solo settle to reach out on your behalf, right, to the plaintiff's attorney. Now, her question was the plaintiff's attorney or the plaintiff. Once they have an attorney, that is the person you should be contacting. And there's a couple of reasons for that. Number one is, like, that's why they have an attorney, is to be the person to interface. And if you contact the plaintiff directly, they'll probably just tell you, we have counsel, so talk to them. But the second reason is because once they have an attorney, what you really want is to either get rid of the lawsuit or stop them from filing a lawsuit. And it's the attorney that has the authority and the ability to do that, right? So yes, you absolutely, if you want to settle a case and you know that they have an attorney, you absolutely should be reaching out to the attorney.
I think in some jurisdictions, and correct me if I'm wrong, Greg, but you're actually required to communicate with the attorney. You're not supposed to bother the plaintiff technically. Is that right?
Yeah, it could be the case in some jurisdictions. And I know for attorneys, we are expressly forbidden from ever talking to somebody who is represented by an attorney. So if I'm an attorney and I reach out to the other side, if I talk to the plaintiff and they have an attorney, like, my bar license is in trouble for doing something like that. So it should always, once they have an attorney, the attorney should always be the person you're contacting.
And that's helpful to know if you're being sued by a debt collector and you have an attorney and the attorney is trying to talk to you about it instead of your attorney. That's helpful to know that there are federal regulations out there that say the attorneys have to talk to each other instead of the parties.
Yes. And so if you have an attorney and an attorney contacts you, the only thing you should ever say is, hey, I have an attorney, here's their contact information. And if they try and push you further, then you need to tell your attorney what happened.
Love it. Okay, we've got another video question, actually. This one's kind of interesting. I'm going to share my screen here again.
I'm getting these text messages from this company, and they are two different text messages every day. And I'm not sure if I should pay this. If I don't pay it, I mean, do I negotiate with them via text message or not? Do I click the link and pay it, or do I not pay it and go down the route of sending letters to this company? I don't know these people, but I do owe Geico and Allstate. I'm happy to pay it, though. It's not a problem to pay it. It's just that I just don't trust these folks, and they don't have a right to do this, to text me. So I'm wondering if there's a legal situation going on that I could take advantage of.
So, I mean, there is potentially, I don't know without having more information, there's potentially a Fair Debt Collection Practices Act violation here. And it might be worth at least talking to a Fair Debt Collection Practices Act attorney in your area to see if there is any violation that you could potentially sue them, which would be $1,000 for every text message. Again, I don't have enough information to say whether that is or not, but it could be. My second thought was, man, that could also really be a phishing scam, right? Like, you got to be real careful with text messages like that. So I will tell you, but you're also looking at this going like, well, I know I do owe Geico money. So like, how does that all come into play? I think what I would do in this case is if it were me, again, this is not going to be legal advice for someone else, but I'm just telling you how I would personally handle this if this happened to me. I would probably ignore the text messages. Ultimately, you have no legal obligation to pay anybody anything until a court rules that you do and grants a judgment to that other person's favor, right? So they can say, hey, you have to pay us this, you owe us $235 and we're texting you and you can click on this link to pay it. You don't have to pay them until they sue you and get a judgment. So for me, if I'm looking at it and I'm like, if there's any chance that that's not real, that I could be getting scammed here, I'm just going to sit and wait that out and see if they sue me. Now, it looked like, I don't see it up there anymore, but it was like about $200. My assumption is that they are not going to sue you over $200. And so they're probably just going to pester you to the point where you get so annoyed you just pay it. And so like, until they give me something where it's a statement in the mail that I can look at and go back and verify with my records that like, yeah, I think I do owe this and I can pay it. Unless I get something like that, I'm probably just ignoring it until they sue me. I don't know if you feel different, Hannah, but.
No, I mean, frankly, I agree with that. I think for small dollar amounts, like $200, the chances of getting sued for that, I mean, it's just not worth it for the company to take the time and the resources to hire a law firm. It's just, and
they're going to have to pay a filing fee of like $100 just to file the case. Like, they're not going to sue you over $200.
Yeah, the chances of being sued for that kind of debt, very low. And same with like medical debts. The debt will probably hurt your credit. It's going to show that there's a collection account on your credit, so it's going to be hurting your score. But are you going to be sued for it? No. Do you have a moral obligation to repay it? Yeah, probably. You probably should repay it. But when it's getting to the situation where you're getting text messages and there's links like Greg said, it could be a scam. One thing that I would personally recommend, and again, this isn't legal advice, but I think what's good to do is, Google search the collector's name that was in the text message and try to find their website. Try to figure out if they are legitimate. If it is a scam, there's probably a lot of information on the internet that will tell you that it is a scam. So before you click that link in the text, go and try to figure out if it's a real collector. And if it is, then you're probably safe to click on the link, look into the account information, see what the debt is that you owe, and figure out if you want to resolve it or not. You might be off the hook, though, if it's as little as $200. Again, it's going to hurt your credit, but you're probably not going to get sued for it and end up in court because of it. So, all right, let's see. We've got a lot of questions on the chat for those watching live tonight. Let's start off with some questions from Juan. So Juan says, let's see. Juan says, what typically happens when a defendant files a lot of motions in a debt lawsuit? What would a lot of motions tend to do?
Well, so, just to start off, a motion is just like you're asking the court to do something. So you file all kinds of motions. I mean, common ones are going to be a motion to dismiss, a motion for summary judgment, a motion to compel arbitration. These are common ones, but you can ask for a motion for anything almost. What happens is when you file a lot of them, I think it kind of depends on, do you have a basis to file a lot of them, right? Like, is there a reason? If you're just flooding the court with motions because you're like, I'm going to overwhelm them and I'm going to give them so much work to do, boy, a judge is not going to like that. Like a judge is going to be like, why are you filing all this stuff if you don't have any basis for any of it? You're wasting my time. And ultimately that judge is going to decide whether you owe the debt or not. So I don't think you want to make that person mad. So, if you're just filing a lot of frivolous motions, what's the judge going to do? Get upset at you, tell you to stop filing motions, and ultimately may not be siding in your favor later in the case. Now, if you have a basis to file a lot of motions, then there's not going to be a problem, but you've got to make sure that, like, legally there's a reason why you're asking the court to do what you want them to do. Now, there are certainly cases I've been a part of where we've filed dozens and dozens of motions. Debt collection cases don't tend to be those kind. You've got a couple of motions, probably, maybe a motion to dismiss, a motion for summary judgment, a motion to compel arbitration, maybe a motion to compel some discovery. But outside of that, a debt collection case is going to be rare where there's a lot of motions. So I would never take the approach of like, I'm just going to overwhelm them with motions. Make sure you have a basis to file a motion before you do it.
Great advice. Yeah. Lots of different motions out there that you can file. If you go to solosuit.com, we have a legal document generator that you can use to draft any type of motion if you're involved in a court case. And we've trained an AI to help with the creation of those documents. So this AI can pass the bar exam in the top 10% and help you, again, just draft a legal document for a very affordable price, $10 per document. So head on over to solosuit.com if you need help drafting a motion. Let's see. We've got another question from Doug. So Doug says, I lost my health insurance last year because I stopped paying my monthly premiums, but Blue Cross would not cancel my health insurance even though they were not being paid anymore. So the hospital would not give me the self-pay rate because I still had insurance. So now they're billing me for the insurance rate instead of the hospital, or instead of the self-pay rate, because I still had insurance. Let's see. He said, yeah, so I don't know.
Yeah, I understand
what he's saying. But
okay, so here's the thing. This is going to be a really contract dependent issue. What does your insurance contract say? So a lot of people think, well, if I just stop paying under the contract is canceled, right? Not necessarily true. You may still have obligations under the contract, right? They may still have obligations under the contract. So this really depends on what does your insurance contract say, number one. Now, maybe the contract probably says, like, when you stop paying, we're not going to cover you anymore, right? Now that comes to the second part of it, which is your fight with the hospital, which is, did you have insurance or not? Now, what are the terms of what are their self-pay terms? Like, how do they get to that self-pay rate versus insurance rate? And if your argument is going to be, I didn't have insurance because under my insurance contract, if I didn't pay, they weren't covering me, which means I'm not covered under that insurance. So I should not be liable for the insurance rate, right? So that's kind of a little bit complicated of an issue, but that's kind of how I would approach it. So if I'm trying to get that self-pay rate, I'm going to say, look, here's my insurance agreement. It says if I've stopped paying, they're not going to cover me, assuming that's what it says. And then I say, and here's the hospital's terms that say when I'm eligible for self-pay, and it's maybe if you don't have insurance coverage, you're eligible for self-pay. And I say, I was not eligible for insurance coverage because under the terms of my insurance contract, I didn't have coverage. That's all going to depend on how the language of those contracts turn out, right? So what I'm telling you may not be applicable to you because it really is going to depend on the language of those contracts.
Do you think there's any chance that Doug could reach out to Blue Cross directly and just maybe they would provide documentation that he missed premium payments and he could prove to the hospital, hey, I was not covered during this period?
Yeah, you could call Blue Cross and see, can I get a letter that says I was not covered on this date? And if they'll provide some kind of documentation you weren't covered on that date, and you give it to the hospital, what's their argument going to be at that point?
Cool. Super helpful information. Yeah, when it's insurance and medical bills, I think documentation. Get everything.
And I'll be honest, that is one. I mean, you can handle that on yourself if you have the means. That is a complicated enough contractual issue. Oh, you would be better off with an attorney on that case. I understand that, like, financially you may not be in that situation, but that is not a simple debt collection case like I typically deal with in my company and Solo deals in theirs. Like, that's a complicated legal issue.
Definitely. And depending on how much the hospital claims you owe, if they're saying you owe $20,000, it might be worth it to hire an attorney. Let's see. I think we have time for one more question. This one's from Thomas Sampson. It says, I got sued by Capital One and filed an answer using Solo denying the complaint, even though it's a legit debt. I plan to settle with them, but was it a good approach to deny the claims initially for them to prove everything?
Yep. I like what you're trying to do with the answer is avoid a default judgment, right? And you're saying, and there's different ways you can do the answer, right? It's been a minute since I've actually gone through the Solo suit process, but typically when you file an answer, you can give one of three responses: admit, deny, or say I don't have enough information to admit or deny. So when people come to me and they're like, I don't really feel comfortable denying because I know I owe it, then I say, I don't have enough information to admit or deny, because what you haven't seen is their proof yet. Now, you may know I owe this debt, but they ultimately have to prove it. You don't have to admit it. So let them say I don't have enough information and let's see their proof. And then once you file that answer and avoid the default judgment, you reach out and negotiate the settlement. And I mean, everybody's morals are different. I don't see a problem with that. And it's what most people do is you file the answer, you're just either denying or saying I don't have enough information because I want to see what their proof is, and then ultimately you can admit you owe the debt later by paying them.
Yeah. I would agree. In my experience working at Solo for the past 5 years, in many cases, denying due to lack of knowledge, I think, is oftentimes the actual legal phrase that is used in these documents. So it's not the same as saying that you outright deny it. Saying deny due to lack of knowledge is exactly like Greg said. It means that you don't know. So when you say you don't know and the collector needs to prove something in order to get a judgment, it kind of can stall the case, which can give you leverage then to negotiate, try to settle before your court date. So yeah, I mean, Again, we can't give legal advice because we're not representing the people watching this, but in many cases, for debt collection lawsuits in particular, that can be a good strategy. Greg, any other last thoughts on tonight's topic of, just navigating debt lawsuits in general, but more specifically in trying to get collectors to produce the documentation needed to prove that a debt is valid and that they have the right to collect it? Any other last thoughts?
Yeah, if I could just give kind of a summary, and this kind of goes to most of the questions that we got tonight. If you're being pestered by a debt collector, you don't have to do anything unless you want to try and settle it, but you don't have to do anything until they sue you. Once they sue you, file your answer before you do anything else. Make sure you get that answer filed by the deadline. Once you do that, you can figure out what documentation do they have. Do they have the documentation showing that you owe? Do they have the documentation showing that they own the debt? And if they've got those things, or even if they don't, you can kind of evaluate that to determine what kind of settlement, and then reach out and try and settle. And that's generally the process that I recommend to everybody.
Yep, and I agree. I would recommend the same thing based on my experience. Filing that answer is going to block that default judgment, and that's your first step in protecting yourself in a debt lawsuit and also reaching a resolution. So, Greg, thank you so much for joining tonight. Really great insights, and we had some great questions as well. Thank you to everyone who tuned in and listened to the Debt Hotline. We host these live Q&As regularly to help people who are navigating debt issues, especially legal debt issues. And yeah, we're really grateful, Greg, again, for having you on tonight. Thanks so much for joining. If you are being sued for debt, don't forget to file your answer. You can do so at solosuit.com. I just dropped a link in the chat. Click on that link, go draft your answer, file it. You can do so in minutes with our help. And then you can use our tool Solo Settle to negotiate and settle the debt before your court date. Thanks again, Greg, for joining. Thanks everybody for watching.